No, it wasn't anything like that. Like I said, I was in a bad predicament, and I was using that to like pay.
All right, what is this charge? Manufacturing delivery, SIM?
Let's break this down. It's not being charged with real drugs. This is simulated controlled substances. So, that means fake drugs passed off as the real thing. Legally still a felony in Texas? Why? Because it's all about intent to deceive and prosecutors hate deception.
Pretty much allegedly selling fentanyl.
Ah, okay. All right. It's
Yeah,
very weird on my.
I think simulated control substance.
All right. And Norma, can you call IT to come up, please? All right. So where are we on discovery? I know he has a new case as well.
Right, Judge. There are two different alleged times that this was sold. So one was indicted. I don't know why the other one wasn't indicted.
Okay.
It's sort of part of the same investigation. But I was informed by Mr. Belcher that he may have some federal indictments coming through or came through.
He does, Judge. So the criminal episode here has been picked up by the feds. He's currently under indictment with them. He has a setting in late January.
Oh, once the feds enter the chat, everything changes. Federal charges usually carry heavier penalties, tighter procedures, and less wiggle room. This local case suddenly riding shotgun to a much bigger ride.
As I understand it, and I've been conferring with Mr. Garahan. And while we've not any concrete disposition, I think there's a strong likelihood that whatever happens there will substantially affect the cases here. My understanding it's a first setting. I know the docket says 2, but I don't ever recall having been.
Oh, I have it as a first setting.
Oh, you do? Oh, okay.
Yes.
It's on the docket.
And I was lied to.
And
So,
not by Jason Garahan.
I mean,
Those are fighting words.
it was an oversight. I'd like
Because
to.
this is how I know it's a first setting here, because I
Okay.
have nothing written on here.
And we're on the same page. I don't know if you can push us beyond.
This is classic jurisdiction juggling. The local court is stepping back to let the feds move first, which often means the outcome there will shape any plea here. It's like legal dominoes, one move topples the rest.
January 27th, because that's his next federal court setting. The more information I learn about what their intentions are, I think the better off we will be to figure out what we are going to do. So that is my request if the court could grant it.
All right. So this can come back. Do you have any objection to his request?
No.
How long do you expect the trial for McIntyre to last?
My side?
Yeah. Well, we're doing.
I think it's 2 weeks at minimum.
All right, because we're doing jury selection for that on February 7th, but we have motions on February 3rd. I can set it for your client for the week of February 3rd, since it's just, is everyone okay with that?
That should be fine. I mean, mostly I think most questions would be contact.
Yeah, there's nothing earth shattering that's going to get, but just more information.
All right, so February 3rd is a Monday. We can do it the 3rd, the 4th, or the 6th.
Just make sure I'm not going to be out of county, Judge. The 4th is a good day for me.
All right, we'll recall this on February 4th, and you say that the feds have already picked up the case?
Yes, ma'am.
All right, and that'll be 2025. Thank you for dressing appropriately for court. Once you sign the reset form, you're excused. Norma Cuellar is being recalled for February 4th, and that'll be for discovery.
Thank you, Judge.
You're welcome.
Just wait outside.
Yes, sir.
Talk to the judge about this or ask for a reset so talk to the victims credit card abuse case.
Court is calling 2024 CR 2669 State of Texas versus Omar Flores. Can I have parties announced for the record? For the state?
Harris Sademan.
Defense?
Scott Hill for Mr. Flores.
Are you Mr. Flores?
Yes, ma'am.
All right, did you review the document entitled Motion to Enter Adjudication? Excuse me, Mr. Ross. No talking behind the court reporter. Just ask the deputies, they'll move you to the other end. Oh, no problem. All right, we're back on the record. Mr. Flores, did you review the document entitled Motion to Enter Adjudication of Guilt and Revoke Community Supervision with your attorney? You need to speak up?
Yes, ma'am.
Did you understand it?
Yes, ma'am.
Are you the same Omar Flores who was placed on deferred adjudication in 2024 CR 2669 for the offense of possession of a controlled substance, penalty group 1, less than 1 gram on June 13th, 2024 for a period of 3 years. Is that you?
Yes, ma'am.
All right, state.
On or about the 5th day of August 2024 in Bexar County, Texas, the defendant Omar H. Flores did then and there fail to complete the substance abuse treatment facility with the BCC SCD in that the defendant refused to sign amended conditions to attend as directed by the supervision officer and or the court in violation of condition number 39.
How do you plead to that? True or not true?
True.
Did you understand by pleading true to violation of condition number 39, the court could find it true, grant the motion, find you guilty, sentence you up to 2 years in the state jail facility and up to a $10,000 fine? Knowing that, do you still wish to plead true to violation?
When you plead true to a violation, you're basically saying, yes, judge, I messed up. No trial, no excuses, just straight to sentencing. And in this case, the judge isn't sold on giving him a soft landing.
Of condition number 39.
Yes, ma'am.
Court will find violation of condition number 39 true. Is there a proposed agreement?
Yes, Your Honor. Adjudicate guilt, revoke supervision, assess punishment under 1244A at 200 days of confinement in the county jail.
I'm not going to follow that proposed agreement. Why
Good.
should I follow that?
Let me give you a little context
Yes.
of why he refused to. First, he got denied for felony drug court, Judge.
Mhm.
They were at capacity, and whatever reason, I don't know why he didn't qualify for it.
Mhm.
He's got 5 children under 8, and his wife was late in the pregnancy when he was, and he's been in custody since May 20th, Judge. And so he was in custody when he entered his initial plea. Once he realized that he's going to have to wait for a bed and being saddened, he didn't want to be, all his thinking is he didn't want to be away from his family that long and potentially miss the
Wait,
birth.
you're saying he's been in custody since May?
Yes, Judge. He's been in nonstop custody since before he took the plea, back in, I believe it was June that he took the plea.
All right, so we're not going to count that part. How long is he? He took the plea June 13th. So he's been in custody since June?
Well, he was in custody before he took the plea.
Well, I'm not even going to consider the time that he's been in custody before he took the plea. All right, so he's been in custody since June when I ordered felony drug court and he didn't qualify for felony drug court.
Correct, Judge.
All right, probation. Why is it that he didn't qualify for felony drug court? All right, felony drug court was at capacity and he said he didn't have a drug problem. And part of the reason why you were in custody, you say since May, is because April you had a court date and you did not show. So a BF was issued. So you were remanded without bond. So that's on you. You didn't appear. And felony drug court didn't accept you because you said you didn't have a problem and they were at capacity. All right, so you may continue.
Judge, the way he's thinking is, I just got to get home to my family as soon as I can. And so, when they're talking around the jail and hearing he's going to be waiting months for a bed, he just, for whatever reason, he didn't want to do that. And he wasn't going to be able to visit his family when he was at SADF. He wouldn't be able to see.
Here's where emotion meets the law. He stayed in jail not because he wanted to, but because he thought it was his only way to see his kids. It's raw. It's heartbreaking. But will that outweigh the court's frustration? That's the million-dollar question.
And so that was very important to him because he can have visits at the Bexar County Jail. So that's why he didn't go, Judge. Obviously, he probably regrets that now in the situation he is, but we're hoping the the court will consider the fact that he's been in jail and custody for so long that that's enough punishment for him.
All right, I'm not going to sentence him under 1244. And with regards to his children, I realize he has children. That's why I ordered parenting classes. And I don't know how he expects to help his children or be present in his children's life when he has a drug problem.
Well, Judge, the whole time he's been in here, he's realized the effect he's had. He's never been away from his family, and he missed the birth of his son. So he hadn't even had a chance to hold his son yet, and that's killed him. He's a family man. He He loves his kids, and he sees what this has done to his children. He's told me I'm never touching anything again. I don't want to put them through this again. So I believe the judge. Now if the court's willing to entertain releasing him back on deferred and maybe give him some outpatient treatment.
Now, what's his criminal history?
As far as I can tell, Your Honor, he doesn't have any.
All right. Did you run PCIC, NCIC?
Not today, Your Honor.
All right. Do you have a TCIC, NCIC? Doesn't matter if it was run today. He's been in custody for a while. Do you have that?
Do not, Your Honor.
All right. So states you need to get that, and then the court will make a decision.
Okay.
All right. Thank you. So this is off. It keeps going in and out. I don't know what's on here.
I would say I step out for a minute. I didn't know if I missed your call.
Gonzalo Garcia.
Good morning. How are you?
Good morning.
How are your IT issues treating you? Like, how they cleared up, or
Well, that is good, but this is now off.
you have a new thing?
Yes, he's working on it though. He's great.
A real professional.
All right. So on this case, where are we on discovery?
We're good on discovery. Had a chance to confer with the state. They are offering a PTD, but they need to speak to the victims first, and that's why they're asking for a reset.
All right, Norma, I need a 30-day reset on Garcia Gonzalo. All right, so we'll come back on January 9th, and then I'll expect an update on PTD.
Thank you, Judge.
All right. Thank you for addressing appropriately for court. All right. So where are we on discovery? I see we have one case that's indicted and several that are not.
That's the problem. We can't go forward until they get those indicted. State can't go forward. They need a lab report on a couple of drug cases, at least.
So when are you all expecting lab reports?
Judge, I was going to reach out to the lab today, but those still are outstanding. And then on one of the cases, the fraud use, we still do need to reach out to the complainant. And so I was planning on doing that today. As far as I know, the lab is backlogged, but if we could maybe have a month, that way I can, ask them to expedite it and get a status update for the court.
All right, Norma, if you'll recall this for January 30th, and it's Jerry McGee. So we'll bring you back on January 30th. If they have something sooner, they'll let your attorney know and you can come back sooner. Any other questions?
No, that's it, Judge.
All right, thank you.
Do I need a reset form or not?
No. Court is calling 2020 CR 7207, State of Texas versus Keandra Marshawn Davis. Can I have parties announced for the record for the state?
Ashley Jones for the state.
Defense. Counsel, you're on this side. And are you Mr. Davis?
Yes, ma'am.
All right, did you review the document entitled Motion to Revoke Community Supervision with your attorney? Did you understand it?
Yes, ma'am.
Are you the same Keandra Marshawn Davis who was placed on community supervision in 2020 CR 7207 for the offense of assault, family choking, strangulation on August 3rd, 2021 for 4 years and extended for a total of 2 years? Is that you?
Yes, ma'am.
State?
Yes, Your Honor, we do have an agreement.
What are you proceeding on?
We are going to proceed on both violations of condition number 1.
All right, if you'll read it into the record, please.
Yes. Violation of condition number 1, on or about the 30th day of June 2024 in Tarrant County, Texas. The defendant, Keandra Marshawn Davis, committed the offense of driving while intoxicated in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
Violation of condition number 1, on or about the 30th day of June 2024 in Tarrant County, Texas. The defendant, Keandra Marshawn Davis, committed the offense of possession of a controlled substance, PG1, in violation of condition number 1.
How do you plead to that? True or not true?
True, Your Honor.
And the state will waive the remaining violations, Your Honor.
Any objection?
No objection, Your Honor.
It's your understanding by pleading true to violation of conditions 1 and 1, the court could find it true, grant the motion, and sentence you up to 4 years in prison and up to a $1,500 fine?
Yes, Your Honor.
Knowing that, do you still wish to plead true to violation of conditions 1 and 1?
Yes, Your Honor.
Court will find violation of conditions 1 and 1 true. Is there a proposed agreement?
Yes, Your Honor.
And what is that proposed agreement?
That proposed agreement is to grant the state's motion to revoke community supervision, revoke the community supervision, and sentence the defendant to 3 years in the Texas Department of Corrections.
Is that your agreement?
That
counsel?
is, Your Honor.
Are you asking the court to follow that agreement?
Yes, Your Honor.
Are you waiving your right to appeal?
Yes, Your Honor.
All right, the court will follow your agreement, sentence you to 3 years in the prison, give you credit for any time served. There's an affirmative finding of family violence. There's to be no contact with Pantandra, Patandra, Booker, Booker. Is there anything else from either side with regards to sentencing?
Not from the state, Judge.
Judge, I believe Mr. David has something to say.
Yes.
We have a child together, and the first time that I was here, you said no violent contact. That was the very first thing you said, and ever since then, it's been
No, because of what I've written in here is when you were first placed on probation, it was to be no contact with Pajandra Booker. Then you had a motion to revoke file, and then that was for a violation of condition number 5. I denied the motion, alternate amend conditions to complete BIP, transfer to Dallas, weekly reporting, the UA hotline, and then in August, this was set for August 24th for a contested hearing in person. And then on August 24th, there was a violation of condition number 15. That judge found it true. And then today, this is where we are. I've never ordered a no home for injurious contact. All right. Did you review the document entitled Trial Court Certification of Defendant's Rights to Appeal with your attorney? Did you understand it and sign it?
Yes, Your Honor.
Because this is a plea bargain agreement, because I followed your plea bargain agreement, and because you waived your right to appeal, you do not have the court's permission to appeal. Because this is a felony conviction and an affirmative finding of family violence, you're not allowed to own or possess any weapons or ammunition. If you have a question over what a weapon or ammunition is, you'll need to speak to an attorney. Do you understand?
Yes, Your Honor.
All right, we can go off the record. Look, you're going to have to change your life. You say you have a child, you want to be in your child's life. I would think that you would want your child to be proud of you. Part of that is stop with your drug use, which alcohol is a drug. If you can't control the usage of it, be kind to your child's mother, which you have not been. We're here for an assault choking. That means you choked her.
4 years ago.
I mean, that's no excuse. You can't say, oh, I shot somebody, but we're back together. That was 4 years ago. Do not minimize what you have done. All right. Good luck to you.
Thank you.
Thank you, Judge.
You're welcome.